Good morning, good morning, good morning, or should I say hear ye for day 24 of the Karen Reed retrial. It is Friday, it's May 29th, and we are getting into the defense case. But first, the attorneys are going to argue that motion to dismiss that we see at the end of every prosecution case, or we do unless the defendant's pro per and forgets that that's a thing. These are generally denied because all of the evidence is taken in the light most favorable to the prosecution because they're not moving for it. And the standard there is, could any reasonable jury on the evidence find the things as charged, find the crimes as charged? And the court, again, will look at the fact that one witness, if believed, can establish any one fact. And if those facts have been established by a witness, if the jury believes that witness, then can this case go forward? So you really only see these granted when there is no evidence to a particular fact. And in this case, we do have witnesses. Again, a lot of you are like, yeah, but I don't rely on that witness. I know you don't have to. For the purpose of this motion, all of the could it be this swings in favor of the prosecution. But we're still going to hear the attorneys argue. We're going to get to hear how they see the evidence at this point. And I'm curious to see how the prosecution articulates their case, because we know how the defense articulates their case. I think the defense has been very clear in how they articulate the case. The Commonwealth has not been as clear, and it's changed a bit. I think the defense, though their defense has shifted, it's pared down. The prosecution case has swung more. So we're going to go see that, and then we're going to get into the defense case in chief, because today is the day for the defense case in chief, and we're going to see the defense calling their tech expert who's new to this trial first. So that's the first thing we're going to do. So, Law Nerds, are you ready?
When they went back and downloaded the data from the infotainment, the key on was logged in the infotainment as 214808. So there's the 3 seconds. That's where they're getting that from. And that's what he states, highlighted in red there. It's a little hard to read, but it basically says the average across 4 runs.
Because they're the seconds. Worst slides
the 3 second
ever.
Delay. Was that actually in his report?
This is the only point in the report it's mentioned.
I guess what I'm asking, it was an inartful question. The portion to the left, is that his report or your report?
That is his report. Everything on the left-hand side of this slide comes from Mr. Burgess's report.
So the 3 second delay was noted in his report?
It was noted.
Did he apply the 3 seconds in his analysis?
He did not.
In your opinion, I asked you about Mr. Burgess's report. Now I'm going to ask you about your opinion. In your opinion, is this new offset any more likely or reasonable than any other offsets previously proposed by Mr. Burgess?
I don't think it is more or less likely. I think it is a valid approach, certainly. And so I think the results from the additional analysis should be included with the analysis of all of the results so far.
Is every data point that we're looking at and that you've been talking about, are these all drawn directly from Aperture's reports?
That's correct. I have not proposed any methods for aligning the clocks myself. All of the methods that comprise these 30 are from the Aperture reports themselves.
Based on your analysis of the Aperture, or your review of the Aperture analysis, is there any ability to say to a reasonable degree of scientific certainty that the Techstream event occurred after the last physical interaction with John O'Keefe's phone?
Yes, there would be three out of the 30 possibilities would result in that.
Right. If you are just joining us, we were just at an extended morning break. We are in the first witness of the defense, who is their tech expert, engineer, accident reconstructionist. And yesterday we were talking a bit about whether or not the defense would come out of the gate with attacking the data that the jury was left with from the prosecution. And that's what the defense has done with this first witness. They have come out of the gate with this witness evaluating the reports of Burgess and Welchure and talking about the timing possibilities when you're trying to correlate the Techstream event 1162-2, the backing event, from Karen Reed's vehicle and the time on John O'Keefe's phone. And what I appreciate that this witness did is they took the crammed and complex slides from Burgess and simplified those down. And instead of this witness just saying everything they did was wrong, this witness said, look, there are some things left out, because if we're following this process, then it opens up more possibilities. And the witness went through 30 different possibilities of timing between the Lexus Techstream time and John O'Keefe's phone, and showed where all those different events fall when you try to correlate the timing, and said, look, there is no way to pick one of these. All of them are equally possible. So with all of them, 3 of them show that the end of the recording of the Techstream event, 11:62:2, happened after John O'Keefe's phone used the manual button click. 2 of them showed it was during, or there was some synchronicity. And the rest of them showed that the Techstream recording ended before John O'Keefe's phone was put into lock mode. And we've seen the prosecution shift their timing a bit in this too, where the prosecution has not said that it was during the 11:62:2 event that John O'Keefe was hit. They said that was the backing event, but that event stopped recording and the car, they argue, continued traveling backwards. So the Commonwealth is allowing the possibility for argument that after the recording stopped, the Lexus was still traveling backward. So wherever that timing correlation is, they're going to argue that they don't know where in that backing event John O'Keefe was struck, but that he was struck during that backing event. But it could be at any point in time there. And so the last lock on the phone being so close in time to the backing event, I think they will argue, indicates that that's what happened. Now, do I think that that is specific enough for all jurors? Not necessarily. But the defense used their first witness to say, okay, so from Karen Reed's car, did Karen Reed's car ever, in the time she was driving that car, 8 months, ever register a collision? No. On January 29th, 2022, during any of these trigger events, did it register a collision? No. Were these trigger events triggered by a collision? No. Were any of the trigger events triggered by a collision? No. And went through no collision, no collision, no collision, no collision. And went through all of it. So we saw more discussion again of pinning John O'Keefe's, or trying to align John O'Keefe's phone to the phone calls from the Techstream or the infotainment system, not the Techstream, and then trying to align John O'Keefe's phone to the 3-point turn before the backing event happens. But this timing is critical because the defense has the easier argument here saying, hey, when did this happen? Because if it could be here, it could be here, it could be here, it could be here, it could also not be. The Commonwealth has to close those doors.
Good morning, sir.
Good morning, sir.
Sir, are you trying to offer an opinion suggesting that Ms. Reed's Lexus never hit John O'Keefe on January 29, 2022?
Objection.
I'll allow it. Is that what you're doing?
Is that your opinion?
No, sir.
Are you offering an opinion that Ms. Reed's Lexus never got in a collision before?
Yes. Never registered a collision.
The way I stated it was none of the prior events were triggered by a collision.
What I'm asking you, are you offering an opinion that Ms. Reed's Lexus never got into a collision before January 29, 2022, or on that day?
No.
So when you were talking about collisions to the jury, you weren't making any suggestion that that Lexus was not in a collision, are you?
I think you threw a double negative in there. Can you just clarify what you meant? Yeah.
You are not suggesting to this jury that Ms. Reed's Lexus did not ever get in a collision before?
No.
Okay. You're just saying that there's no data on the Techstream to suggest a collision.
Specifically, none of the events were triggered by a collision.
It wasn't triggered by a collision. It's never going to be triggered by a collision, ever, on Techstream data.
Not the collision in and of itself, correct?
Because Techstream doesn't trigger for collisions.
So there's other things that will trigger Techstream data,
Correct.
like sudden acceleration.
The only acceleration trigger that I'm aware of on Techstream is if there's a large acceleration during what Lexus calls a PCS, or a pre-collision safety event. But a large acceleration on its own, I do not believe is one of the triggers.
Are you sure you know a lot about Techstream data?
Yes.
Sustained.
It's
You know a
argumentative.
lot about Techstream data?
Yes.
Let's summarize the morning. We are at lunch. I think we're maybe midway through cross-examination, it would seem to me, of this expert. And Brennan, I think at points has done a very good job of using this expert to point out what his experts did well. And he's also used this expert to solidify the points he wants to make. He said and asked this expert, are you saying that Karen Reed's car was never in a collision? No, I'm saying that a collision was not registered in the EDR system, and one would expect that a collision with a pedestrian would not register in that system. It's not a significant enough impact to the car. We heard that from the Commonwealth experts too, that EDR system is really keyed towards registering vehicle to vehicle collisions, not vehicle to pedestrian collisions, and they wouldn't necessarily expect that that would register. They, I think, also went through maybe more clearly than witness Burgess did about the second chip-off procedure that this witness was also present for, where Burgess took out the SD card. What the witness was critical of is that they had a fully different procedure prescribed for what they were going to do that day. And then Burgess was like, but there's an SD card here, we're taking that too. And this witness said Burgess didn't explain what he expected to find on the SD card. My takeaway from all of this was that Burgess didn't really know what was on the SD card, but because Burgess wasn't sure if you had the totality of the information because of the bits versus bytes issue, Burgess's confusion about bits versus bytes led him down a rabbit hole that he wouldn't have gone down otherwise, to look for that SD card. And then when he found the SD card and started downloading it, remember, Burgess's background is more in phone technology and mobile technology than vehicles, though also in vehicles. He went looking for that SD card, and the SD card happened to be where they stored the date and time that connected to the key cycles. So there was new information on that SD card that took the key cycle 1162 and had a date and time for when the car turned on with that 3-second variance. And that's why we've not heard as much fighting over the key cycles. Was that super clear when Burgess testified? No. But did Brennan make it more clear in cross? Yes. And I think that's because Brennan is much more adept at doing cross-examination. He is traditionally a defense attorney, and that does not surprise me. But he, I think, asked good questions of this witness to point out the information that Burgess found. Now, does that make Burgess a better witness? I think it clears up the information that Burgess got that this witness then said was valid information. So do I think this witness a bit bolstered Burgess in not discounting everything Burgess did? Yes, I do. But what I think the purpose of this witness was, and where the defense has room to argue with this witness, is that even though I'm relying on all of this information from Burgess and Welchure is accurate, they narrowed it down too much. And there's no reason to narrow it down that much because all of these different time variances are possible, which is really the power of this witness. All of these different time variances are possible. So yes, relying on their data, and yes, taking everything in this data as accurate and true, it was narrowed too much. And that's really the point of what this witness is here for. So where we see Brennan starting to get into the weeds is, well, did you download the data yourself? This witness is like, no, I just assume that you're experts, and this witness would never say that. He has been very polite. But this witness essentially said, no, I relied on your experts to do their job, and I took their data as true. And I relied on the data that they got. I wasn't here to download new data. I was here to evaluate their data and see if it was reasonable to narrow it down to one time variance between the Lexus clock and the phone clock. And the thing is, there's too many factors to pick one. All of them are reasonable. So I'm not saying they did it wrong. I'm saying they narrowed it too much. But I relied on their data. It's interesting that Brennan went down that road of questioning so much about, well, you didn't download the data, you didn't do this, because the witness didn't challenge the data. The witness never said that the data was unreliable, that the data wasn't accurate. He just said it's broader. So it was interesting how much Brennan went down that road that I don't think he needed to go down. And are you saying that this witness shouldn't rely on it? Like, what? I don't think that's helpful at all. I like how the witness testified. I think even on cross, when he pushed back on, I need more clarification, it really came across, not that he was being evasive, which we've seen from some experts in this case, but that he was truly trying to clarify, like, are you talking about this or this? Which I appreciate from experts. No expert's just going to adopt what they're told on cross. But also when Brennan said, I think you said this, and the witness said, I'm not sure I said it exactly that way. Brennan read it from the report and said, do you want to see this report? And the witness said, no, that sounds like what I said in the report, which is a stark difference from so many of the Commonwealth witnesses saying, well, let me see the report. Well, where is that written? Well, let me see this. Well, let me see that. This witness was like, no, yeah, that sounds like what I said. Mm-hmm. The grasp of his work is different. And the only time this witness really shaded anything were those horrible PowerPoint slides from Welchure. And I don't fault him for it because God damn, those PowerPoint slides were awful. They were so crammed full of information. This witness did a good job, I think, of parsing that information out and making it more clear. And I saw that from all of you in the chat today, too. All of you said, you know what? I understand this better because of the way this witness explained it. I agree with you. There are things that I took from the other testimonies, but it took some work to get there. This witness didn't require work to understand what he was saying. It was just laid out. And even on cross, he's laid things out very cleanly. It's not confusing. It's not evasive. Yes, no, this, that. It's the kind of expert testimony I like to see. And he didn't go the extra mile of disparaging any of the work done by the other witnesses, which is notable because you can already see Brennan laying the groundwork for our experts touched everything. Their experts didn't have hands-on to anything, which for some jurors can matter. I don't know if it will matter as much for this witness, but it may matter for the later witnesses. And that's what Brennan is going to lean into as the differentiator. But our experts touched it. Our experts had the car. Our experts got an exemplar. Look at the work our experts did. Okay, your expert also had 7 different CVs. We haven't forgotten. He found an SD card. Fair. But also, I have not forgotten all of the evasiveness with the education because I did not like it at all. And both things can be true. The SD card closes the door to the conversation about what day that 11/62/2 trigger event or key cycle happened on. It's timestamped to the car. Did that come across clearly for you in the Commonwealth's case in chief? Did you clearly take away from Burgess's testimony that the information on the SD card was the date and time of the key cycle 11/62/2, tying it to after midnight on January 29th, 2022? Or did it completely get lost in everything else that that witness testified to?
Part of my conclusions would change. I wouldn't agree that I'm wholesale wrong.
Well, as a scientist, if they're not accurate, that would be wrong, wouldn't it?
They're not wrong, though.
That might be a nuanced answer.
I'm sorry?
I said that might be a nuanced answer. Frankly, I'm not sure how to give you a good answer to that
If
question.
you have the wrong data when you're doing your analysis.
If you have the wrong data when you're doing your analysis, the data comes from your experts. If you have the wrong data, the data from your experts, sir, you are lost in the forest at the moment.
Then the final analysis is going to be wrong if you have using the wrong data. It's that simple.
Yes.
Right? You don't have to be a scientist to figure that out.
Argumentative.
Okay. If we could have Mr. Welcher's 33.
So whose data were you using? Theirs? Okay.
You were asked about whether
For all of you saying, how
The
can he have the
windows-
wrong data when he's relying on their expert data? Brennan's trying to say he's interpreting it wrong because he interpreted it the way it was labeled.
you were asked just a second ago. What about the data? What if it's wrong? Then you'd be wrong, correct?
Generally, yes.
Garbage in, garbage out. Basic scientific postulate, correct?
Generally, yes.
You're relying on whose data?
Mr. Burgess's data and Dr. Welcher's data.
Thank you.
Period.
All right, Mr. DiSogra, you are all set, sir. So you can step down. I'm going to see counsel for a minute. Jurors, feel free to stand up and stretch if you'd like.
And that was the point of the direct. Whose data did you rely on? Well, that would be their data. So the jury is out for the day at the end of Mr. DiSogra's testimony. I think Hank Brennan made some good points on cross-examination. However, I have to wonder if those points were lost to the jury because Brennan kept fighting over things that just weren't being contested by the witness. And when you keep fighting over the same point, the witness keeps going, yes, I agree. And then you fight and fight and fight, and the witness goes, yes, I agree. And then you fight and fight and fight. At some point, the jury's just going to go, okay, stop it. And what he was fighting over was the chart from Mr. Burgess that had the infotainment calls from Karen Reed's phone and the calls on John O'Keefe's phone. In Burgess's testimony, he said that he did not consider those first calls that had a timing variance of 1 or 2 because those calls were downloaded into the Lexus infotainment system from Karen Reed's phone after the car was turned on. He only considered the calls when Karen Reed's Lexus was powered on. And the witness agreed, yes, those calls all happened when the Lexus was powered off. The witness said, however, we don't have any testing to know the way that the Lexus imports the information from an iPhone. We don't know if it adjusts it. We don't know if it just takes the time off the iPhone. We don't know. That wasn't tested. It's assumed. So we don't know. And then Brennan went down a whole rabbit hole of, okay, you're assuming. And he goes, no, I'm relying on what they said. They assumed. And he goes, but if you're relying on bad data, then your analysis is bad. Which led to the very, very end. The last question from Alan Jackson was, whose data did you rely on? Well, Burgess and Welcher's. I don't understand why Brennan went so far into, well, that chart says calls from infotainment system. You assumed they were from the infotainment system, but you were wrong. The witness is like, well, it says it on the thing. And it's not noted anywhere else that it's not that, but it was in Burgess's testimony. And at the end, the witness said the analysis wouldn't be wrong. You would just take out those data points. So if you take out those data points, it's what, 4 or 5 calls? Okay, so you take out those data points. So instead of 30 points, you have 25 or 26 points? Okay. The witness was like, okay, then you take them out. But it was wild watching Brennan continue to fight on, but you don't know what that really says when it's so clearly labeled. Whose fault is it if the labeling is unclear? This expert or not? But we see what Brennan's approach is going to be with the defense experts. You didn't download the data yourself. You didn't do the analysis yourself. Earlier on, before lunch, Brennan made, I thought, a good amount of headway showing that there were things that Burgess connected in that were helpful. And then after lunch was sitting there going, but you don't even understand this chart. Well, the jury and all of us can see how the chart's labeled. So if the confusion is there, whose fault is it that it's confusing? And I don't think it's this expert who I thought was very clear on what he evaluated and what he didn't evaluate. And Brennan made some very good points with this expert that I think will probably get lost in all of the fighting over the labeling of that chart. because the fighting over the labeling of that chart just is so overdone for me when the chart clearly says what it says. It could have been two questions. Well, you don't know why Mr. Burgess did not use those numbers. No, I don't know why he didn't use it. Fine. Burgess's testimony stands on its own. But he continued to go in on it. And the point that was lost was that this expert very much agreed that the point in time closest to the key cycle, 1162.2, was the 3-point turn maneuver. And that is the more reliable time to sync the clocks to. And that is an incredibly good point for the Commonwealth that's buried in the middle of a bunch of pissing over what the thing is labeled. And I think it's going to get completely lost over the fighting of, yeah, but you relied on what my expert says. Because in the middle of it, the expert agreed. Yes, the best points of data are the closest in time to the 1162.2 event, and those would be the most reliable place to apportion any variance in time. And that's what the Commonwealth experts did. But because Brennan went so far down the rabbit hole of, but your data's wrong, when he relied on their experts, I think it gets lost because he's fighting over his expert data. And this witness agreed with him a lot. And he got, I think, lost in the sauce wanting to fight with the expert. Because ultimately, I think this expert largely supported what the Commonwealth expert says. But I think the impression that's left at the end of it is that this expert says, well, yeah, if the data's bad, I can't rely on it. And Brennan harped on it so much that maybe the jury's now going, oh, maybe we can't rely on any of it. Which was not my takeaway of the defense's expert saying, look, there's 30 data points. And then we narrowed those back down to, yeah, these are the ones closer in time. But the impression that's left at the end of it is, well, are the Commonwealth's experts wrong? And I think that's because of the way Brennan wanted to go in and fight. Instead of saying, oh, so you agree with me. You agree with these experts. You agree that this all happened, that 1162.2 happened on January 29th at whatever the time was after midnight. Oh, you agree that this happened. Oh, you agree. There were so many points where he agreed. So it's wild to me that when the Commonwealth was making headway to support their witnesses, that they chose to fight with this witness instead of continuing to say, so you agree with all these things. It, I think, will have the opposite impact of what Brennan was hoping to accomplish because of the way he went about it. And I imagine the defense was probably frustrated during cross that there were times where this witness agreed and supported what the Commonwealth witnesses said and said, yeah, closest in time, use the 3-point turn to narrow down the clock variance. It seems that all of the experts agree that that is the appropriate time for the clock variance. Or the jury's going to walk away with, okay, so everybody's relying on bad data, throw it all out. Which I don't think is what anybody wants, but it might be the result. So at the end of today, we had a voir dire of one of Michael Proctor's friends. The defense had brought a motion, which I suspected included some of the people who might have been on Proctor's text thread. And they wanted to call these witnesses to authenticate the text threads or the text chain of Michael Proctor. What does that mean? It means to bring a document into evidence and say, this is what it purports to be. These are texts. These are texts from Michael Proctor. To prove that those are texts from Michael Proctor, somebody has to say, yes, these are texts from Michael Proctor. And the natural next question is, so bring in Michael Proctor. It seems the defense is trying to avoid bringing in Michael Proctor because they said in their argument at the end of the voir dire, if the prosecution wants to call Michael Proctor on rebuttal, then they can. It seems from the argument we've seen today, the defense wants to authenticate those texts and bring them in so they can argue them without calling Michael Proctor, which I'm going to have to think about a bit more because they are trying to bring an evidence to Michael Proctor's state of mind, but they are not barred from calling Proctor as a witness. I'm going to have to think about that and research it a bit. It's different when it comes to like Karen Read's interviews. The Commonwealth cannot call Karen Read. She's an unavailable witness. So they can bring in other things for state of mind. But when it comes to Proctor, he's an available witness to be called. I don't know if you can just bring in the texts to go to state of mind without calling Proctor. So I'm going to need to think about it as well. But the defense is arguing that they can authenticate the text and say, hey, this is the text thread. You can authenticate these texts through the friend. And the friend can say, yeah, this is a text thread. Yeah, that's Chip. That's Proctor's phone number. These are Proctor's texts. But that friend only had one text in the thread and said he doesn't remember it. He said, we've had this group text running for years. These are people I've known since like, what, 5th, 6th grade. This is a friend group that is ongoing 30 years of a friend group. And so, yeah, I don't remember that exact text, but yeah, I know these numbers on the text. Yeah, I recognize them. This is the friend group that's on this text. And the Commonwealth is arguing, if you want to bring in Michael Proctor's texts, you need to bring in Michael Proctor. Yannetti is arguing these texts are not hearsay. They're not being offered for the truth of the matter asserted because they're being offered to state of mind and bias, and they're authenticated by the friend. And Yannetti argued, and I disagreed with his argument on this point, Yannetti argued, if the prosecution wants to cross-examine the witness about what was meant by those texts, he can. He can't. You can't cross-examine the friend as to what Proctor meant by the texts. It's speculative. The only person who can be asked about what Michael Proctor meant by the text is Proctor. Now, the friend can be asked, what did you mean by your text? But you cannot cross-examine the friend as to what Michael Proctor said in the texts. And Yannetti argued these are not being offered for the truth of the matter asserted. They're not being offered to prove true what Proctor said. They're being offered to show what he was thinking. And then they can argue that for their Bowden defense, that this shows his state of mind in this investigation, why he investigated some, why he didn't investigate others, why he said, oh no, the girl's fucked. Oh, but isn't the homeowner a Boston cop too? Isn't he going to catch some shit? Nope. That's what the defense wants to put in, it seems, without calling Proctor. And again, I don't know if the court's going to allow it because no one can then be cross-examined about Proctor's state of mind because they're just texts. But I want to look at what the cases say in Massachusetts too. This is going to go over the weekend. The court's not going to give a ruling on it. And again, Brennan did the same argument that we saw from him before. I'm not trying to block these texts. But if you want to put the text in, you got to call Proctor. And the prosecution might be right on that because you can't cross-examine the paper. It's interesting to me that the defense is looking for a way to bring the text in without bringing in Proctor. Because Proctor is a whole bag of worms, just an entire bag of worms. I'm interested to see what the judge is going to do with this. I am going to look at this a bit more. We will have an answer on Monday. We had another witness that was ordered back. We will see what that witness has to say when they are called in. It seems on Monday. And we are off and away into the defense's case in chief. Just the one witness today with another witness ordered back. And now the defense is exploring whether or not they can get Proctor's texts in without bringing Proctor in. But if they do that, well, it's going to be interesting to see how that all plays out. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.